Now, I will say that even though I was raised in a law office, I have been in a courtroom my entire life. So,
You know why I was trying to figure that out? Is that information sensitive?
no.
I have literally been practicing law 3 times longer than both of you put together. So
When I told you last night that
sooner or later I'll get the hang.
Yeah. When I told you last night this guy's kind of a big fucking deal, I wasn't joking. He's very experienced, very knowledgeable. And he'll give you his CV here in a moment. But he goes around to many different conventions and gives talks on IP issues, on business issues, on things like that. So it's a big deal that he contacted Toad and said, I want to come talk to the furries.
Yeah, he volunteered. Thank you, but
Okay, well, we are at start time and it's your panel, so get to it.
All right, so it's 4:30 and it's time for Legal Horror Stories. I am your host, Gravio's Toad. In a minute here, we're going to let each of my co-panelists here introduce themselves and give you kind of an idea of their area of practice. And then I figure once we get through that, we'll open up the floor to questions, and we may or may not respond to what you're saying, but we will fill this time. All right, so I'm Gravio's Toad. So I've been practicing law for about 4 years now. I've worked in bankruptcy primarily, so I have cost a lot of people a lot of money over the years, and I am semi-proud of that. I've also been working as in-house counsel for government staffing agencies, so completely, wildly different area. So pretty much my legal experience at this point has been taking vast amounts of information and then learning them really quickly, and then doing something else immediately afterwards. Do you have more experience? You want to go ahead?
Oh, sure. My name's Mark Whipple. I use my real name on Twitter. I don't know why. Sometimes I don't make good decisions, obviously. I have been practicing law for coming up on 24 years. And hopefully I will soon get the hang of it. I have spent most of my career as a corporate counsel. I was a general counsel of a couple of different tech companies. And if you ever played the computer game Axis and Allies, the first release, I am the engineer who launches the V2 when you successfully do V2 research, because nobody else in the office had a collared shirt on that day. So if you see the picture, that's me. I am licensed to practice in the state of Illinois, as well as registered with the Patent Office, which is a nationwide license for prosecuting patent applications. I do mostly tech stuff, and I make a lot of smart remarks.
You guys have no clue who I am, right?
We found him outside.
I'm Boozy. I go by my real name on Twitter, but not the one any of you all know about. I am a litigation and trial attorney in general practice. I have just gotten back into criminal defense. What that means is I will do literally anything that may have a chance of going to trial at some point in time. I also do ham and egg stuff like wills, estates, simple divorces. But the majority of my work, I would say about 90% of my practice, is civil litigation and trial work. Probably about 5% is the ham and egg stuff. Another 5% is criminal defense work. I am licensed to practice in the Commonwealth of Pennsylvania. I am admitted to the United States District Court for the Eastern District of Pennsylvania, the Western District of Pennsylvania, and the Middle District of Pennsylvania, the U.S. Third Circuit, and the Southern District of West Virginia.
Those are all the same place.
Pretty much. It's like it's all in one state, except for West Virginia. West Virginia is my wild card.
Just change the signs on the door.
Yeah.
Where in Pennsylvania can you not do it?
I am licensed throughout the entire state of
You
Pennsylvania.
could have just said that.
Yeah. Well, no, actually I couldn't, because there's a difference. And that's a wonderful first question. There is a difference. You are licensed to practice law by your state. When you are licensed by your state, be it by the State Bar Association or, as in my state, by the Supreme Court of the state, you can practice in every state court. However, every court has its own bar. The U.S. district courts are each one separate bar. So there are 3 districts in Pennsylvania, the Eastern, Western, and Middle District. When I was admitted to the U.S. District Court for the Eastern District of Pennsylvania, that meant I could practice law in that single federal court. It did not mean I could practice in the Middle or the Western District. I had to appear before a federal judge in each of those districts and get admitted to practice there as well. The circuit courts are completely different. They're the appellate level courts to the district courts. Just being admitted to a district court does not allow me to practice in front of the circuit court. I have to apply for admission to the circuit court. It's the same thing with the U.S. Supreme Court. You have to apply for separate admission to the U.S. Supreme Court. I have not done that. They do a rather thorough background check, and I don't want to have to explain to one of the deputy clerks of the U.S. Supreme Court, yeah, I'm the furry guy now.
And to make things even more fun, where I practiced in the Northern District of Illinois, there is a general district court and a trial district court bar. And you have to be approved to the trial bar before you can actually do anything. The general district court bar basically allows you to go into the courthouse without the bailiff hitting you.
Yeah. And speaking, if you want to know how important this is, you guys go to the federal courthouse. Has anybody ever been to the federal courthouse? Okay, when you go in, those gentlemen that are standing by the metal detectors, those are not like TSA agents or court security officers. Those are fully armed and experienced U.S. Marshals. The U.S. Marshal Service provides all courtroom security and protection for the United States courthouse system. My admission means I don't have to take my belt off when I walk in. I have a bar admission card in the Eastern District that I can show to the U.S. Marshals. It means I have been background checked. I get to go on into the courthouse. You assholes get everything searched.
Okay, we must do something different in Georgia because I get searched.
It is specifically each court sets their own rules.
Northern District,
Yeah.
everybody gets.
Yeah, it is every court gets to set its own rules, and that's even true in your state court system. And where I practice, where the majority of my practice is Philadelphia in their criminal court, my bar license, my attorney's license, gets me sped through the process. I'm a licensed attorney, they know me, I'm registered, I get through, I don't have to be searched. In, say, the Berks County Court, Reading, Pennsylvania, everybody goes through. I go in and they check me for knives tied to my ankles. That's not a joke.
Well, he does have a history.
There are other counties where my bar card means I get to keep my cell phone in the courthouse. You guys have to check yours with the county sheriff. So every court sets its own rules of decorum. It'll actually be in your local court rules for that courtroom on how they govern that, or at least in my jurisdiction, a president judge's order that they sign, and then it's put on there, and everybody's expected to know what it means.
Okay, so I think we kind of got our mileage out of that one. Anybody have any questions for us? Okay, yeah, I do want to.
There's a mic.
Oh, sure.
We gotta make you walk.
How dare you?
Dance.
So, without naming any names, what's the most relaxed judge that you've ever had to have a court case from?
Nothing.
Mine's the easiest because I've only been in court like 60.
Mine's quick, so I'll just jump.
Yeah, go right
The most
ahead.
relaxed judge I've ever been in front of. I have only been in front of a handful of judges because if you're in bankruptcy courts, at least the types of bankruptcy that I was doing, Chapter 7, you walk in, you say, Your Honor, Radio Stone here for the debtor, and we have no objections, we have nothing to say. And they pretty much just kind of go through the motions, you write up the order, that's it. So the only time I've actually had to appear in front of a judge, one of these cases was, oh, you've heard this one.
Mm-hmm.
So my very first time in front of a judge, as a matter of fact. So I had a slight scheduling error. I had a hearing written down for the wrong time, and while I had called my client, earlier in the day, saying, "Hey, your hearing is today. You don't actually have to be there. I can take care of all of that." She decided, you know what? I'm going to show up anyway. I got a couple of questions for the car company. When we're going to surrender the car or whatever. So she shows up, and I'm not there. It's a 10 o'clock hearing. I have 2 o'clock written down for some reason. And so at 10 o'clock, I'm kind of just going through my email, reading the news online or something. And I get a series of texts and phone calls within a couple of seconds of each other from all the rest of our attorneys down at the courthouse saying, "Where the hell are you? You have a client here, and the judge is about to call them up." So luckily, I was within walking distance of the courthouse. So within 5 minutes, I flew down through the federal courthouse, got searched, did all that, had to take my belt and shoes off, and still managed to get there just in time to hear the judge say, "Now, I don't know where your attorney is, but he better show up on time next week for the show cause hearing." So basically I went in the next week and said, "Your Honor, this is the situation. I had the wrong time written down, that no harm was done to my client." And basically, once I finished my piece, I got to stand there for 10 minutes while she tore me a new asshole. So that's the most relaxed judge I've ever been in front of.
10 minutes is nothing.
I know.
Yeah, let me explain, because I am in courtrooms. I'm in courtrooms at least twice a week, either on a routine matter or on an actual hearing. The word for what you just described is malpractice. And we've had this conversation when you told me that before. Now,
This stays between us.
yeah. Now, quite frankly, would he ever get dinged on it? No. I mean, and judges will understand that. But that's literally how important it is to be on time to court and to double and triple check your calendars. My malpractice insurer actually investigated my office's calendaring system or diary system. We have to have 3 different backups of our diary. I have an electronic diary that goes through my email that my paralegals are linked in on. We have an old paper calendar in the front of the office where everything gets written down on. And then we have a desk diary that I carry in my briefcase for things. And my malpractice insurer wanted to see all of them to make sure that we didn't miss hearings or things like that.
And this is why you should have gone into patent law.
Oh, yeah.
Because when you're filing patents, normally you file a patent application, you get a response. It says on it how much time you have to respond, and it always says 3 months, because it always does. But it's not really 3 months. You can buy more months one at a time. It's awesome.
That the most relaxed judge I've been in front of, we have a dual judiciary in Pennsylvania. We have what we call the minor courts, and then we have the Court of Common Pleas. The minor courts are what we call lay judiciary. They can be lawyers. They're not required to be lawyers. So yes, I mean, the guy hearing your case in the minor court could literally be a car mechanic that's just really well liked in the community. They have a legal boot camp, a judge boot camp that they go to. It's 3 days, and then they are set loose to render verdicts upon the world. The Court of Common Pleas judges, which you always hear, who's familiar with the term small claims court? Okay. Everybody thinks
small claims court.
Everybody thinks, like, you hear small claims court, that's where any case below X amount is going to be heard, right? No. In Pennsylvania, there is no limit on the jurisdiction of the Court of Common Pleas. Somebody can sue you in the Court of Common Pleas, which is our full trial court, over $1. It will not happen. There is a saying in law, non curat de minimis lex. The law does not concern itself with trifles, meaning a case of no consequence will be dismissed. The minor judiciary has a limit of $12,000. You have the option to go in front of them before going to the Court of Common Pleas. The Court of Common Pleas judges are all lawyers. They're all elected. It's what you think of when you think of court. I divide them in my very unprofessional way of saying real judges and unreal judges. And I have said this to clients who have then repeated those words in court, and it has not gone over well.
Which is why he at least says unreal and not pretend.
Right. So when you say judges, my mind immediately goes, do you mean a real judge? Because my real judge, the one that's most relaxed, is a guy I love. He, in the time I've been practicing in front of them, he has never ruled against me once. And the reason that I love him so much and that he is probably the most relaxed goes back to when he was invested, when he was elected to the bench and given his robe, his very first day in court. Now this guy's a very experienced lawyer. So it's I'm not impugning his intelligence, because he definitely knows how to pronounce the legal terms. He definitely knows what he means. But guys, you have been practicing 30, 40 years. You have just been elected judge. It is your first time on the bench, and you are nervous. Maybe you are not thinking straight, right? We had a cattle call. A cattle call is where there's a bunch of cases on the list in the morning The attorneys, if they are there, show up. The judge calls it. You stand up. You say you're there 9 times out of 10. The question they have is, what is the status of the matter? You tell him what's going on. He goes, okay, update the court within a month or we're going to have you back in and we'll do this again, right? A lot of people will not be represented at the cattle calls. And when they're not represented, they are listed on the docket as, and say Jones v. Smith. Jones v. Smith, Jones' attorney will be under the name in italics. If Smith's representing themselves, it'll say pro se. Pro se just means for themselves. They don't have a lawyer. This judge got on the bench, and as he was calling the list, attorney so-and-so, attorney such and such, and then goes, Attorney Prosy. Is Attorney Prosy here? Guys, this went on for like 10 minutes of him calling the docket. And you don't correct a judge. It's considered bad form, but you can't laugh at him either. The bar in the area that my firm is in is a small, tight bar. We all know each other. So as he's standing there repeatedly calling for Attorney Prosy and getting more and more irritated that Attorney Prosy is not present, we're just kind of all looking at each other going, who's gonna tell him? Finally, somebody waves over the sheriff's deputy who's acting as bailiff and they whisper something to him. And the deputy goes over to the judge's courtroom secretary and whispers something to her. And the secretary leans over to the judge and whispers something to him, and the judge goes, "Is Mr. Smith pro se here?" Okay, then moving on. Now, it seems like a funny story just because of that, but you got to remember this was like 3 years ago, and to this day we still refer to him as Judge Prosy. But not to his face. And if he ever finds a video of me telling this story to a room of people, whether I've mentioned him or not, he will never rule in my favor. So thank you for that.
Hey, you're the one that told that.
I'll riff on that real quick before I tell my own personal judge story. I don't usually go to court. I'm a corporate and transactions lawyer is what the terms usually are used. But I do pro se volunteering for people who have special needs children who are doing guardianships. And the first time I appeared in the next county over from the county where I usually practice, I went in. I had never been in that courtroom before, and when you do that, you go in, you throw yourself on the mercy of the judge's clerk, and you kiss up, and you'd bring chocolates and roses if it was allowed. But that's the level of kissing up that you need to do, because those clerks will make you or break you. So I go in there, and I've never been in this court before, and I go up, I sign in, which is what you do when you get there, and I get the court listing, which is the listing of all the cases, exactly what he said. Normally it's, party, attorney, and then for everybody else. In this court, however, it doesn't say party pro se. There's just nothing next to their name. So I get up there, and I am the first attorney. My client is the first client who has an attorney. So up above me are like 3 or 4 people with nothing next to their names, and then me. So the bailiff is getting ready to call a first case. The bailiff walks over to me and says, "Do you represent all these people?" And I said, "No, why?" He said, "Well, your name is listed next to all their names." I honestly don't know if he was messing with me or not. If he was, he is wasted as a bailiff and should be on the stage. I kid you not. I was like, "No, I'm with this party." He's like, "Oh, okay. Maybe they don't have lawyers today." Okay. But it was that same judge who I'll give you as my most relaxed judge on this one thing. Normally when you do a guardianship, whoever the guardian is has to be evaluated by the court to make sure they're suitable to take care of someone who can't take care of themselves. The court appoints what's called a guardian pro tem, or
Ad litem is what we use.
Ad litem is another term that's used, whatever. And that person is usually a lawyer who's been practicing family law for a long time, knows all about it, and they investigate. They may go to the house, they'll check out the medicals, make sure this person really needs help, whatever. In every other case I've ever done, you do this, the guardian ad litem is paid by the person who's doing the suit, and they usually make more money than I would if I was billing.
Yeah.
It is a very complex job in some ways. It's a very responsible job. They get paid very nicely. They're all, like I said, they're all attorneys. So I'm sitting, I've never been in this county before. And one of the other attorneys, I'm talking to one of the other attorneys, and any tips for this courtroom? She's like, be nice to the clerk. I'm like, okay, got that one. But she's like, oh, did your judge meet the respondent? Oh, yeah. Oh, well, this judge will let you waive the guardian ad litem. And my judge went, I've never heard of this before. I honestly almost wasn't aware that it was allowed. And so I'm like, okay. She's like, well, normally you go in and you have an interview with him, and if he's happy with him, I'm like, okay, but did he meet him? Yes. So I go up, you know, it's the first hearing. This is normally where that guardian gets appointed. Then we come back in 90 days or whatever, and the thing goes through. He's like, well, what do you want, Mr. Whipple? I said, well, you know, Your Honor, you may recall you met the respondent. He's a great kid. He just wants to live with his parents. Everybody's happy. You know, he's thriving. And we were hoping, and I just like tossed it out. We were hoping we could just waive the guardian ad litem. He looks at me and he's like, oh yeah, I met that kid. Sure. Here's your guardianship order. Thanks. Come back in 3 years. And I never got that attorney's name, and I feel so bad because I owe her a giant fruit basket. And my client owes her 3 or 4 because she saved my client, you know, could be thousands of dollars. And I'd never seen that before. So now I have to ask every time, is this a judge? Although, actually, I'll do one more quick one if that's okay. Right when I first got my license, I went out of law school and became the general counsel of a company, which in hindsight was very, very poor decision making on their part. But it worked out, it was fun. And a year or so after I started working there, it's a small consulting company, an innovation company, about 15 employees. They have the first floor of a big building in one of Chicago neighborhoods. And somebody breaks in the back door, goes into the shop where we make models, steals several $1,000s worth of tools, makes a mess, and leaves. Now we have an alarm system now, obviously. The alarm system went off. The alarm company called the cops. The cops drove by, saw the front door was closed and locked, and drove away. So then, of course, the next day we come in, the back door is still propped open to make it easy for them to get in and out with their loot. So we call the cops again, we file a police report, we get a police report. And then in the city of Chicago, shopkeepers who don't have a lot of money or who live in dangerous neighborhoods used to do this thing where they'd set off their burglar alarm on purpose when they had a good day so that the cops would be there when they ran the receipts out to the car. And, you know, the cops didn't like that, understandably. And now Chicago gives you a ticket if you have an alarm go off and there was no break-in. So we come back and my boss finds out not only did the cops not even check into this, there's a $500 ticket on the front door, and he just loses it. He is incensed, and for a good reason. So he's like, you're going to fight this. So I go down there, and it's a magistrate. It's not, you know, it's a pretend, an unreal judge. It's down in the bowels of the Daily Court Building, if you know where that is in Chicago. And it's just this guy. He doesn't even have a stenographer. He has a tape recorder. He's sitting like in a folding chair, I swear, like we are now. He is the court. And there's a bunch of people who are honestly, you know, shopkeepers or small business people. And there's me. I've been practicing a year. My license still squeaks when it goes around corners. I've got a suit on. I've got my briefcase. And, you know, I had gone around to the people who found the break-in, and I actually had them prepare affidavits that they had found it. I had my ducks in a freaking row. So he calls cases, you know, Mr. Smith, Mr. Jones. Well, I don't know what happened. Okay, well, you're going to have to pay a ticket. Calls me. And I say, Mark Whipple for the defendant. It's like, oh, well, what's your position? I say, I'm the general counsel of the company. And his eyes kind of open up a little bit. He's like, I take it you're contesting the ticket. And I said, yes, Your Honor. I called him Your Honor because why wouldn't I? And he's like, on what grounds? I said, on the grounds that our offices were broken into. He's like, oh, well, what evidence do you have? And I said, I have an affidavit from the person who discovered the break-in, and I have an affidavit from the person who cataloged the loss, and I have a police report. And he's like, Okay, he looks at him, doesn't even look up, just look through him, doesn't look at me. Doesn't look at me, turns to his tape recorder and says, based on the evidence presented before me, I enter a finding of no liability, case dismissed. Then he reaches over and turns off his tape recorder. And he looks up at me again, he says, by the way, the rule is that if you have a police report, you win. But the affidavits were a really nice touch.
Do we have another question? Oh my God.
Wait a minute, that was a good question, so you get a prize. Come over here.
Yeah, there's door prizes, by the way, apparently.
I will kick the stairs to avoid liability.
Yes. You get a magic stick.
It's
that
not
can
my
make
kind. I
magic
can wave into Wisconsin, please, trip and fall. It's your panel, buddy. Pick someone.
I saw you with the pink ears first.
Yes. What is the purpose of the metronome?
What's that?
What is the purpose of the metronome?
It keeps time.
You know, I literally
What
am sitting
metronome?
here wondering the same thing. I'm just saying.
What metronome?
Thank you for asking. I didn't want to say anything.
I think this was like a social experiment. He was going to sit there and have it go and see when we said something.
You get a magic stick too. And a fish, because you said you wanted one.
Use the stairs.
All right.
Toad.
I saw you in the front first.
It's not. You're a turtle now.
Okay.
And he has a persona.
You the blue right there? Yeah.
In my own experience, I've hired a lawyer and then went the entire initial meeting without telling him that the person I ran into was a cop. Have you ever had a situation where you go to court and the client just left out some extremely important detail?
You guys want to share the panel, everybody?
You guys want to share a knowing silence for a second?
I very recently had a chance to talk to a class of 1Ls at the law school I attended. And I will pass on to you the same information I passed on to them. Every client lies to you. Maybe they don't do it by telling you a lie, but they definitely lie to you when they leave out some important details, like, and I had a felony in Maryland.
Or I won the lottery while in my bankruptcy.
Or I would like to patent this invention, but I've been trying to sell it on YouTube for the past 3.5 years.
I didn't hit his car, but I did hit him with the bat. Or my personal favorite. Before I was in private practice and actually getting paid, I worked with Mid-Penn Legal Services, which is a pro bono organization. This was actually while I was still in law school. It was part of a clinic. I was on what was called a limited license to practice, which means I could represent indigent clients in every court in the Commonwealth of Pennsylvania under the supervision of a faculty attorney who never actually appeared in court. They just had to sign the pleadings I was filing. I did all the appearance, all the argument, all the research. It's a wonderful, wonderful way to give people in law school practical experience of what it's like to represent people in court. I did a lot of unemployment cases. One of my unemployment cases insisted that they had been fired because the manager did not like them, and they had broken some minor rule, but they had been told they weren't going to be fired, and this and this and this, and I was young and naive and believed them. And I continued to believe them after doing the intake and asking all the questions you're supposed to ask. And I continued to believe them as they sent me documentation that seemed to indicate it, and I continued to believe them right up until we got to the hearing. and they took the stand. And when asked, while on the stand, why were you fired? They said, well, I broke some rules. Well, what rules did you break? Now, this person was a caretaker at a halfway house, is probably the most ambiguous way I could put it, for people who could not care for themselves. And she said, well, they said it was inappropriate conduct, but it wasn't inappropriate. Now, I had been through this with her, and I had asked what it was, and her explanation to me was she had had a fight with her manager, and she may have called her manager a curse word. And I thought, that's not fatal, that's not too bad, we should be able to help here. When they said, what was the inappropriate conduct to her, and this was a referee asking her this, she said, well, I mean, it was my boyfriend I was having sex with on shift, so it wasn't that inappropriate. We walked out of that hearing, and she looked at me and said, so how do you think we did? And I said, you're applying to other jobs, right? She goes, yeah. I go, okay then, and just got in my fucking car and drove back to the office. Because how the hell do you respond? The fact is, your clients will leave out, and it's human nature, they will want to leave out anything that makes them look like they are in the wrong. They will lie to you. They will lie to you constantly. You have to kind of get to a point where you smell bullshit like a fat kid smells cake. And you do stuff like when a client leaves your office after an initial meeting, you start Googling them and going through their Facebook and their Twitter accounts and their LinkedIn and seeing if they've lied to you about anything. And if a client starts to give you answers that don't sound right, you start picking them apart. I have had clients, when they tell me their story in prep for a hearing or testimony, who will want to punch me because I go from being their friend and lawyer to cross-examining them. And when they get angry, I say, let me explain. This is what the other side is going to do to you. If you don't want to punch me by the end of this meeting, I'm not preparing you. And they will come out with stuff. The best part of representing a client is when you can call them out on being a liar before they have a chance to tank their entire case on their own. Because they always think, gee, I can hide it on the stand. No, you can't. The person who's going to be questioning you makes their living yanking these threads apart. Don't lie to your fucking lawyer.
All right, so who else we got? So you right there. I saw your hand first.
So where'd the other person who asked the question get the
Yeah, where's the one who gave me PTSD?
You get a fish because you upset Lucy.
Okay, so kind of on the opposite spectrum, the police always say you have the right to remain silent, which basically means shut the hell up or you're going to die. What's the best case of somebody not shutting the hell up when they really should have shut the hell up?
I actually do have one for this.
Yeah, you go first.
And I can't get into the details of this one without identifying the person, but there was a spot on the news about it. So that's how I found that one out.
The joke among lawyers who do criminal defense, and it's very well known, you guys probably know this, is everyone has the constitutional right to remain silent, but none of you assholes have the ability. Guys, when you're arrested, the DA has access to the police dash cam and body cam video. It goes into the DA's file. During the course of your criminal trial, I am permitted to demand discovery from the district attorney's office, and they will give it to me. But they normally don't give it to me until I've had to go out to court and argue with it, because DAs are assholes. And they will make my life a living hell. That's just how it works. We play games about this crap. Like, you may be looking at a murder charge somewhere, like me and the DA are having a pissing match over one document. That doesn't mean anything, just because we can, just because we want to screw with each other. It is never a more clearly defined case of they are the enemy in criminal law. In civil practice, you're not the enemy. We work together on cases. It's cool, we're dicks to each other, but then we like walk out of the courtroom like, hey Ted, do you want to go to the bar tomorrow? In criminal law, oh my God, prosecutors and defense attorneys hate each other. So it's a bad sign when you're arrested and you call me and I call the DA to let them know I'm entering my appearance, and like an hour later the DA's entire fucking file is in my email inbox, because that shit doesn't happen. Let's go to lines I have heard on the dash cam video. The marijuana's in the trunk, officer. I only had 8 beers. I don't remember why I was naked, but I looked in the wrong window. I was going for the bathroom. You assholes need to shut the fuck up. And while we're on the subject, stop putting shit in your email that's going to incriminate you. Because I mean this civilly as well. Stop putting shit in email. I tell clients every time you hit send on an email message, before you do it, think, do I want to read this on the record at my deposition?
And if nothing else, by the way, even if that doesn't happen, do you really want a room full of lawyers who are doing document review, reading your emails and mocking you? Because we do.
Oh, you don't want to know some of the penises I've seen when we get emails in discovery. Why the hell are people sending dick pics through corporate accounts? And they're not sending them to like employees or shit. It's like they're emailing them to themselves.
Or
Like it'll be
nice
Ted
lady from Backpage?
Yeah,
Don't do that.
Ted Johnson at bigcompany.com to tedjohnson@gmail.com. And I'm like, is Ted just emailing his dick to himself daily?
The company camera is much nicer than him.
Yeah, I mean, what's going on with Ted? You learn a lot about people by reading their emails.
It gets archived.
Yeah, and you know what? They get pulled, they get sent to a lawyer, and we're like, I know way too much about this guy.
I have seen literally somebody, leading a document review thing, which is a room full of lawyers just going through things that have all been scanned in. Nobody actually looks at those stupid papers anymore. It's all on computer. And I have seen the lead reviewers say, I have seen the previews for today's batch. If any of you are uncomfortable reviewing them, please let me know and I will reassign you for today. That's how bad it was. A room full of lawyers, and he was worried that half of them would get grossed out. That's wrong. Knock it off.
So yeah, there we go.
I'll give you one that happened to the other side.
Oh, I want to hear this. It's always funny when it happens to the other side, though. Let me just be clear.
This was in when you register a trademark with the federal government. There's an office called the Trademark Office, believe it or not, where you file this registration application. They process it, and there's 2 hoops that it has to jump through. The first hoop is that the government will assign an examining attorney. The examining attorney has to look at it and say, no, you cannot register a trademark for McDonald's for your cheeseburger stand, Mr. Smith. That name is taken. But once the examining attorney says, okay, this will work, then they publish it in the Federal Register and everybody else on earth has a chance to object to it. And if they object, then the trademark office basically starts a trial in the trademark office. It's very similar to a trial that you'd see in court, only it's with judges who are just trademark lawyers who think they're judges. I was representing a client, and I can just go ahead and say this because this is a matter of public record. Who here has heard of the Church of the Subgenius?
Yes.
For a time, I was an attorney who worked for the Church of the Subgenius. And they were trying to renew one of their trademark registrations. And if you have heard of the Church of the Subgenius, you might understand that, they attract very interesting people. Including people, for whatever reason, were trying to oppose it. It had gone through the first step, the trademark examining attorney had said fine, but then somebody else filed an objection. And so they filed an objection. The objection is usually pretty simple. It's just, I don't think they should get this because I'm already using it. It's 99% of all. And the examining attorney didn't find it. Or he did find it, or she did find it. But they said, no, it's not close enough, and this guy says, yes, it is. So I answered and said, no, here's the history of the use of this mark, everything's fine, I don't know what his problem is. We go into the trial, he files his initial filing. His initial filing, and this was back when they were still on paper and I had to print it out, I kid you not, was this thick. And not one word in it made a lick of sense or was in any way related to the actual questions being addressed in the trademark case. And so I filed a response, and my response, after all the boilerplate and the respectfully asserts and all that good stuff, that you can never file a one-page response to anything because the boilerplate is going to be 4 pages. But my actual response, I'm going to paraphrase it slightly, and it can actually be looked up online. It's still in the T-tabs here. It's all public knowledge. Was this? Respondent has no idea what plaintiff is trying to say. And I filed that, and what actually happened was he was required to file a response to me, and he never did. And after his time ran out, I filed to have his objection waived because he hadn't done his paperwork, and I got it, and the trademark registration went through. But literally, all he had to do was say, here's why I don't think you should have it. I used it first. The stars are not aligned, whatever. But he filed this brick, and the examining attorney had to, or the patent judge, the trademark judge had to read it. He had to read every page. And at that point, I could have not only moved to have his objection waived, I could have moved to have him flogged in front of the trademark office, and I probably would have gotten it.
Enforcing it may be a different matter, but
All right, let's get somebody from over on the
For
side.
the record, I'm a Discordian.
My condolences.
Hail Harris. Side, you in the back with the
blue hair.
yes.
For the,
Oh, it's our male stripper, yes.
Good to see you again.
Good to see you too. For the patent attorney, what's the most ludicrous patent you had to work with? Like, is there any that you just had to, like, that's like just been laughable, or?
And that's the panel, everybody. You get a fish. Actually, no, that is a really good question. The question is, what is the most ridiculous patent? He said you had to work with, but that could mean a couple of different things to a patent attorney. He could be asking me that somebody has asked me to file, or he could be asking me about a patent that's been cited against me. Probably the funniest one, I don't know about most ludicrous, but the funniest one was that my client had licensed a property to a major manufacturer. The manufacturer had manufactured it and was very successful. And I don't know, 3 or 4 years later, after it was already on the market, the manufacturer gets a cease and desist letter, which means that somebody thinks that they have a patent on this item. And of course, it's in the deal. Since we licensed it, this is now my problem. My client doesn't actually make anything, but we've agreed to indemnify them, to defend them, and to make it up if something goes wrong. So they send me the cease and desist letter. And I'm looking at it, and my first response is, this patent might read on this thing. And then I look at the date that the patent was applied for. And then I go and look up when did my client start selling this thing. Now the rule is, you cannot get a patent on something that has been on sale to the public for more than a year before you apply, because you're not allowed to go around patenting things that everybody already knows about. The basic social transaction behind a patent is teach society how to do something that we don't already know how to do, and in exchange we will give you a monopoly on doing it for a certain period of time. If you don't teach us anything new, you don't get a monopoly. That's the deal. So I went and looked, and I was 100% sure, as sure as you ever get in law, so 99% sure, that I had a valid on-sale bar to this. And the thing is, that doesn't mean he can't enforce the patent against me. That means that the patent is invalid, and it has to be thrown out. So what I did was I wrote him a very polite letter basically saying, you know, I have documentation, some of it I'll share with you, some of it I won't, that, you know, you are barred, that your patent is invalid. And what I said in lawyerese was, go away or I will go to the patent office and have your patent invalidated, and then you won't be able to bother anybody. And I never heard from him again. But as far as silly patents, I mean, there's books and websites that, I mean, I don't even know where to start. I mean, there's a patent on method of swinging on a swing is an actual patent. Method of creating a peanut butter and jelly sandwich is a real patent. Who here, by the way, I'll give you one that's not quite as obviously ludicrous, but is even more ludicrous. Who here is a computer programmer or understands at least a little bit about computer programming theory? Of the people who just raised your hand, who knows what garbage collection means to somebody who's writing computer code? All right. There is a patent, I kid you not, which was issued in the last 15 years for the method of memory management known as garbage collection in a video game. Now, if you know what I'm talking about, you immediately just made a horrible face. If you don't, it made no sense. What they did was they took a method that has been known since at least the early 80s, if my research was correct, and possibly earlier. And they said, you do that, but you do it in a video game. And that's a patented combination. And I was like, you have got to be freaking kidding me. Because I did study some computer science in college. And I'm like, are you insane? Because they sent me a nasty letter saying, you know, I see that you're selling electronic video games, and if you're doing, basically if you're doing garbage collection, you want like
that stuff. Like,
go
what is the
away. I don't care what the examiner was smoking that day. I will not let you do that. And if you want, I don't know, I think this was a patent troll before they were called that. And so they would just like try to see who they could get to pay. And like, if they ever actually tried to make anybody pay, the patent would just be invalidated. That's ridiculous. So anyway, it went away. But that's a good example of one that's, you know, not entirely nonsensical, unless you know what your subject is. But it's like, are you freaking kidding me? There's a patent on that.
Yeah, so you're in the back? Yep.
Can you hear me from there?
Yeah, we may want to, you were repeating your question.
Do you want your prize?
In as much as you can tell us, what's the least cooperative client or type of client you've had to deal with in the respective fields?
How long do you have?
Like, what is it with you guys? It's just like make boozy supper day.
horror story.
Guys, all of my clients are uncooperative once they realize that I'm not buying their bullshit. Okay, that there comes a point where I ask the question and their response is, well, why do you need to know that? And when I say, you don't really need to know why I need to know that, but I do need to know it, I want an explanation. Fine. I think they're going to subpoena the pictures of you and your girlfriend's panties. Are there any in existence? I don't think that I'm paying you for this type of treatment. Let me point something out. Anybody in here work retail? I'm going to say some words and you're all going to groan. The customer is always right.
Why did you do that?
The moment a client says those words to me, I get to live out every one of your wet dreams. Because I have a standard response. Would you like to hear my standard response?
Yes!
The The customer may always be right, but you are not a customer. You are a client. I am not your employee. I am your attorney. You are not paying me to work for you. You are paying me to represent you and provide you with counsel. You are paying for my knowledge, my skill, my expertise, and my connections with the attorney who is suing you for a substantial sum of money. I do not work for you. You are not my customer. The customer may always be right, but you are the dipshit who's the defendant. If you think that is paraphrased, it is not. I am a litigation attorney. For the most part, I represent people. People occasionally have to be beaten, even by the folks that are on their side, to get it through their thick fucking skulls that not cooperating with me is not in their best interests. So I have had plenty of uncooperative clients, and if they do not like it when I tell them, I am not your employee, I am your lawyer, and you are a moron, I will tell them the next thing when they get offended, and it is, come by my office and pick up your fucking file. You're fired. You work for me. No, I am your lawyer. I can fire you as easily as you can fire me, and I sure as shit will if you make my job impossible. You would be amazed how cooperative people get when you terminate.
When people don't cooperate with me, it's usually not quite as life and death, almost literally, as it is for Boozy, because as I said, I do corporate transaction stuff. But I have had clients do what I call, because I'm old and I grew up in the sticks, taking the bit in their teeth. My clients, for the most part, have been self-made people who have been very, very successful. They're very intelligent. Literally, two of my clients were actual rocket scientists. So they really knew what they want. They had been very successful. And one problem with working with people like that is that they are used to being right. And it's very, very hard to explain to them that while, yes, you're very intelligent, yes, you're very accomplished, yes, you are a subject matter expert in this field, and yes, you're right, from practical layman's terms, this is the most ridiculous thing anybody's ever done. Legally, we have an issue. And getting them to accept that and spit the bit out so that I can steer them where they need to be to not get sued and lose over what is, as we recall from a moment ago, the most ridiculous thing ever, can be very challenging. And one advantage of that, though, I'll lead you out with a song, is that I have had clients who were very successful, who took what they did very seriously, and basically, you know, I couldn't tell you how many times I've said, you need to settle this, you need to do, you know, this, it's not, you know, me sitting here telling you this probably cost you more than it would have to just make it go away. But occasionally you do get an absolute, you know, I'll use the polite word, scoundrel, who is just trying to basically extort a settlement out of somebody. And the best feeling in the world for a corporate transaction attorney, I mean, this has got to be right up there with beating a solid murder rap, I kid you not, is the client telling you, I don't care what it costs, and I don't care if we lose. You're going to take this to the freaking ditches, and then we're going to dig another ditch. If I have to go to the Supreme Court, I'm willing to do that. And I'm just... That's the good part of having those... Because, again, monetarily, and for me and for you when you're doing civil stuff, your best interest is me saving you as much money as I can, unless for some other reason that finding of liability is going to come back and bite you again, which it can. Yeah. But otherwise, my job is to get you out of this for as little money as possible, 99% of the time. But that 1% of the time, that is, it's just so much fun, and usually it's because there are externalities. You know, I've done this multiple times, so it doesn't even identify a client or a defendant. when I do intellectual property work, trademarks, copyrights, patents, I've had infringers who are really kind of nickel and dime, knuckleheads. But knuckleheads now have this thing called the internet, and they talk to each other, and they learn from each other. And it's kind of like how if you mash up a flatworm that can swim a maze and feed it to another flatworm, that's about the level they work at. But eventually the flatworm will swim the maze. And I've basically said, knock it off or I'm going to sue you. Oh, well, you're not. And then all of a sudden, like, okay, you are now looking at, because you're a dumbass who lives in another state, and B, you're just a dumbass in general. You are now looking at a federal copyright lawsuit. I can't sue you for copyright in your own state's courts, even if I wanted to. You've left me no choice. I now have to pull you into federal court. And the reason I did that was because all the other flatworms will learn that they can do this too if I don't make an example out of you. Although, one more, go. This is the best settlement discussion ever that I've ever had. You will like this. You may have heard this. Go. Had a client who had a just absolutely blatant breach of contract case, but the defendant was a Spanish company. And so I call them up, I write them a letter, what are you going to do about it? And they didn't even bother to contest it. They're just like, well, yeah, maybe we did do that. What are you going to do about it? We're in Spain. I don't know how to say it in a Spanish accent, but imagine it. In a Spanish accent. And I said, this is what I'm going to do. Flatworm. I retained Spanish counsel, and I sued them in Spain on the contract. And they're like, holy crap. And so, of course, as I said, dead to rights. No way they lose. I don't care if the judge is this guy's father-in-law. He loses. It's that bad. What happened? The day before we start trial, we get the call. Oh, we want to settle. No kidding. This is my shocked face. So he says, oh, but he says, and this is my American lawyer who's running the Spanish lawyer, because I'm like 2 levels away now. He says there's a tradition in Spain that when you settle, you forgive interest. And this had dragged on for 3 years, so the interest was not nothing. And I said, really? Is that so? He says, yes. I said, well, you tell him this. Tell him that in Chicago, we have a tradition. Where if you steal from me, I have your legs broken. And we can use his tradition if I can use mine. And he said, do you really want me to say that to him? And I said, yes, I want you to say that to him. I said, I'm not telling you to do it, but I really want you to.
We have my personal favorite client that my office had, and I love him to death. The town that I practice in, the city I practice in, used to be run by the mafia. Like up until the 80s, it was a genuine, honest-to-God, mob-controlled city. We used to say no one died inside the city limits. They were always polite enough to step right over the line before getting shot. And that tradition has carried over. There are a lot of construction trades and suppliers in my area, and I represent one. Do you all know the saying, millions in defense, not a penny in tribute? Okay, but essentially what it means is we don't care what it costs, they're not getting shit from us. This client I like much, much more because he has turned that phrase into something much more accurate to how we pursue law at my firm, and especially with litigation cases and how I pursue them. Fuck them, blood or bankruptcy. I was once contacted by the VP of Finance for this company. He said, I don't understand why we're spending so much on legal fees on an uncollectible amount. And I said, talk to your boss. And the boss brought me in on a conference call, and as the VP's explaining how many thousands of dollars are being spent on legal fees to pursue judgments against people who are just going to file bankruptcy, the boss says, I don't pay him to be a pansy, I pay him to be a pit bull. It has gotten bad enough that with my client's finances, I call you, I introduce myself, and when you say, well, we don't really have the money, I say, well, maybe you should talk to X, Y, or Z company about that. They'll tell you how reasonable they are. They went out of business. I know. Here's the upside of that, because it sounds stupid to say that, right? You know what's happened? Over the 3 years I've represented this company, they have become the only contractor supplier whose bills are 80% paid on time, in full, and when due. Because contractors are scummy guys. Not, I don't mean it, but it's just a kind of a tradition. You let invoices stand out there, you negotiate a settlement, you move on, they give you credit, that's how it became. But the word got out that if you fuck with my clients' budget books, we will either put you in bankruptcy or we will take your damn house. So you better pay. And that's the upside of spending thousands of dollars on a debt that becomes uncollectible and millions in defense, not a penny in tribute, and fuck on bankruptcy or blood, because people start to recognize that shit. And I hate to say this, that is personally my favorite part of the job.
It's 5:30, so I think
Quick question?
we do one quick one.
Okay. What's the technical difference between a lawyer and an attorney?
About $100 an hour in most jurisdictions.
That's really it. Look, the guy who walks around saying, I'm a lawyer is a lawyer, okay? The guy who walks around saying, I'm an attorney is a lawyer who's charging you about $100 more an hour, as Mark just said. Unless you're in a small town, then we have attorney at law on our cards, because Esquire is too pretentious.
And actually, on that note, I actually got stopped from getting on a plane because stupidly, these guys will know that you don't do this. This is, to put it mildly, gauche. But I booked the flight with my name and then followed it with a suffix Esquire because I could for the first time. And so they stopped me. It was not on my ID, obviously, and I was not allowed to board the plane.
All attorneys do that for about, my rule is I'll cut them slack if they've been out of school for less than 2 years, because we all do. And then after 2 years, if you keep doing it, you're either trying to scare a layperson or you're a pretentious dork.
Yeah, in my area, and it is kind of regional to some extent, because when I was growing up, I grew up in a legal family. If somebody wrote something to my father's office and signed an Esquire, I'd go, what a prick, and throw it out. I mean, that's what it was. He's like, fucking write me without the Esquire, we'll talk. Where I practice now, you don't use Esquire with other attorneys, but you always append it when you're talking to a layperson or in your first official communication to another firm. The reason is you're kind of putting them on notice, hey, a lawyer's writing you. This isn't a paralegal, this isn't the secretary, this is the lawyer. After that first communication, you don't put Esquire on shit. If I'm talking to another attorney, you tell Dear Mr. Morris, and sign a Boozy Badger Esquire. Fuck that. And after that first communication, it's, Yo Bob. It's like on letterhead, no shit, I have written the words Yo Bob at the top. I mean, you guys seem to think we're always formal. No, attorneys to attorney, we are not formal after the first time we talk. After that, it's we know each other now. We're on a first name basis. I had one lawyer write me and correct me on the pronunciation of his last name. Don't do that shit. If you're thinking about going to law school and you do that and somebody mispronounces your last name, don't write a letter correcting us, because you know what I make a point of doing now? And I think that's our time.
All right, thank you guys for coming. I've been Radio's Toad, Smart Whipple, Boozy Badger. We're all on Twitter. Feel free to follow us, chat with us, whatever you want to do. Thank you for coming. You've been a great audience.